Sandler, are you plugged in?
I am plugged in.
It shows that the input's coming from council table 1B.
That is where I am plugged in, Master. Wrong plug.
Yes, ma'am.
Technology is great until it's not, if I can tell them.
That's all I got, sir, right there.
Is it still not coming up, Your Honor?
The input is council table 1B. I can try 1A and see if that helps. You've been using 1B all the time.
1B, sir, yes.
No, ma'am.
I might need to drag it over, but this isn't coming up either.
We had your desktop earlier, but
Your Honor, it's not even allowing me to drag it over to the other screen. This screen's not even working. If we might take a 10-minute recess.
do you want to try, is there another plug for 1A?
I'm plugged into 1B. Yeah, but it's the court screen is not working.
It's strange that your laptop, your desktop came up and then it just went off after you started doing something. There you go. Good, thank you. Thank you.
Thank you. Ladies and gentlemen of the jury, I thank you for your patience and your attention this week in this very serious case. They don't call it a trial for nothing. And that's what this has been. It's been a trial. The state has admitted a great deal of evidence to go to these elements. That's the law that the judge has already given you. The state only has to prove three things. One, Jackson Barnes is dead. That's uncontroverted. Two, the death was caused by the criminal act of Maria Rodriguez Barnes. We have a lot of evidence of that. Primarily, we have the evidence and I won't take it out and show it to you again at this moment. But we heard from Dr. Deanna Oleski that there was a gunshot wound of 2 inches or less to the body of Jackson Barnes, that his little Cookie Monster shirt was burned and his little body had a barrel impression. That means that a gun was purposely stuck up to the side of a 5-month-old infant and a trigger was pulled. That is a criminal act, and that was done by Maria Rodriguez Barnes. How do we know that? The scene. You saw the video from Deputy J.D. Burnham. You saw her there. They found the gun in the truck. They found little Jackson Barnes in the truck. They found her outside the truck. 3, it's got to be premeditated. The law in the state of Florida doesn't fix a time for premeditation. It can be done in a moment, an instant. It's just enough to reflect. I'm sorry for what I'm about to do. That means that somebody knows what their next thing they're about to do is wrong. That means they've reflected. There is no statement that shows premeditation more and shows planning more than that. I'm sorry for what I'm about to do. If you look at the timeline evidence in this case, and I'll go back to this. If you look at this case and you look at the evidence, there's been so much of it presented. Premeditation is really the issue here. Where did this occur? This occurred at the boardwalk where you heard Richard Barnes propose to her. She had to plan to drive to the boardwalk. The boardwalk had significance and it had meaning. She thought about it and she planned it. The notes. There's a handwritten note in the car found in the center console. To my loving parents, all needed information is in my safe and in document binders in my clear storage tubs. Bear in mind the documents found in the safe. I'm so sorry. Please make sure Jeremiah is taken care of. I'm so sorry for taking Jackson with me. But this is my final and only option. In the top left drawer of my room is further instructions and information. I love you, Lakeisha, now Maria. At the beginning of this trial, there was a stipulated record put into evidence. You are free to look at it that shows that her name used to be Lakeisha. This was in the truck waiting. Now let's look at the timeline. She started this note to Mom, Dad, and LJ, 3/24/2020 at 8:46 p.m. The night before. The night before any of this occurred. A long time before. And I'm not going to read you the whole note, but I'm going to read you an excerpt. I know this is a permanent solution to a temporary problem, but it's my choice. It was her choice. She chose to do this. That's premeditation. And I'm so sorry, and I know it's selfish, but I cannot lose Jackson too. For all of Jackson and mine things, please sell, return what you can. What does that indicate? She's taking Jackson with her. The text message to Richard Barnes was received at approximately 7:30 a.m. If you look at the Wild Willie's surveillance video, you'll see that before 7:30 a.m., she was already in the boardwalk parking lot. She was already there before she sent the text message. She already had her plan in motion. She tried, she really did. She was sorry it wasn't enough. And you can see from the text messages that Mike Evans indicated to you, those are the messages from Mr. Barnes back. His concern for what's about to happen. Because she just told him, I'm sorry for what I'm about to do. And then she sent him this long missive. You're free to read that yourselves. I'm not going to read the whole thing out to you. An exact copy of that message was found in her notes app from her phone. The phone found on the ground next to her that Mike Evans told you was her phone, Maria's phone. What's telling in this note, I told you I won't read the whole thing to you. She says, I'm sorry if I made you feel like you couldn't be yourself. Go be happy and do what makes you happy. I'll give you the freedom now to do that without the worry of me or Jackson. That's premeditation. After she pulled the trigger on Jackson Barnes, after she let his little body slide to the floor, discarded, after he no longer served his purpose as a pawn in her divorce, and she took his life, there is evidence she injured herself. There's a call from Brian Douglas the morning he called in, and you heard that call. And at any point in that call, did you hear Maria Rodriguez Barnes express any concern about her infant son in the vehicle? Why is that? Because she already knows her son is dead and that there's nothing that can be done for him. Because she already knows she killed him a while before. You heard Deputy J.D. Burnham testify that his body was cold. And that was less than an hour, or right at an hour from the time she sent that text message to David Barnes. Now, how do we know it wasn't anyone else? How do we know it was her? We know this again from Wild Willie's surveillance. We know that she comes in, we know that she parks, we know that she's there the whole time. If you want to watch the whole hour of footage, you may. No one else approaches that vehicle. No one else gets out of that vehicle but Maria Rodriguez Barnes. And that timeline lines up with the phone call, the text messages, and everything. And that's the scene, that's the boardwalk. That's her phone on the ground. And in the front seat was Jackson Barnes. And the reason why he was moved from the back seat to the front seat was that was when, as you heard from Mike Simmons, they were trying to see if there were any life-saving measures that they could take. And they couldn't. Now they're on scene. These are photos from the scene. Her gun on the ground and 2 spent shell casings. How do we know that's her gun? The serial numbers. We absolutely know. We know because in evidence you have paperwork from the safe, even though it's a different name, Maria Rodriguez Laria Claret. It's the same address, and it's the name that you'll see in those Department of Highway Safety records. That was one of her names. And she bought that gun from Jimmy's pawn shop, and that is absolutely her gun. You'll see it on the trace report, and you'll see it on the Glock box that was recovered from her bedroom. That is her gun. The shell casings, you heard Jeff Foggy, those absolutely came from her gun. You also heard from Christy Hoffman that she recovered 2 projectiles. One was from the back pillar area of the truck, Maria's truck, and you heard testimony. That was absolutely her truck. You heard it from Kelly Henderson. She got that projectile. She said it fell out. It was tested by the Florida Department of Law Enforcement. Jeff Foggy said that projectile came from that gun. And Jennifer Wilkerson said that projectile had only Maria Rodriguez Barnes's DNA on it. Now, Christy Hoffman, this is the back seat of the truck. She dug through the back seat of the truck and she found a projectile in the back seat of the truck underneath the foam part of the seat. And you saw earlier in the autopsy photos how there was a trajectory on Jackson Barnes's body that went through his back. This is the projectile that went through his side, through his back, down into the seat and underneath. And Christy Hoffman retrieved this projectile. It was sent to the Florida Department of Law Enforcement, and it absolutely came, you heard from Jeff Foggy, from Maria Rodriguez Barnes's gun. It was also tested, and the only DNA on it was from Jackson Barnes. Identity is not at issue, but we have all the things from the center console. Her driver's license, her military ID, that was her. That was her driving that day. And all the things I just talked about from the Florida Department of Highway Safety. She went by Lakeisha. At one point she was Maria Rodriguez Claret, then she was Maria Rodriguez Barnes. And she purchased that firearm from Jimmy's back in 2018 with that same serial number. Everything she said in that first note was located at her residence at 740 Butler Drive. Just like she said it would be. What's really important for you to listen to here is that she admitted it herself. When Kelly Henderson went to serve a warrant, she said, "I shot my son and myself." She got up on the stand today and she told you she doesn't remember any of the issues from that day. She just doesn't remember March 25th of 2020 at all. Whether or not she remembers is not an element of the crime, even if you choose to believe her, which the state would submit that you don't. With all of the evidence of premeditation and planning and notes. She had everything laid out because she had a plan, an intent to kill Jackson Barnes. The state asks you to not be distracted by her injury. We ask you not to be distracted by what she did or didn't do to herself, because that's not part of the elements. That's not the law you've been given, and that's not what you're charged with deciding.
I'm in the middle of it right now. Let me take care of this part and I'll call you back and see you. Okay. Do you remember us? Yeah? Okay. You know why we're here? You don't remember us talking? No? You know why we're here? Yeah. Why are we here? Can you go ahead and turn it off for me?
She shot her son and she shot herself. The important part about that is she shot her son. She shot her son at close range, and you can tell from these autopsy photos, again, close range. With wounds he could not have survived from. She absolutely knew what she was doing. You heard Dr. Oleski testify that there was soot and a muzzle impression in the wound track, and that was very close contact. I bring it up again because she absolutely knew what she was doing. Because she called David Barnes that morning, Richard David Barnes Jr., he goes by David, and wanted to talk about their relationship. And he told her, it's over. So she told him, I'm sorry for what I'm about to do. She was already in the boardwalk parking lot. She hit send on a text message. And she decided to take the life of her son. And the state submits to you, that was a way to get back at Richard David Barnes. She took the only thing from their relationship that was precious, that was the physical representation of their relationship. And because it was actually over, he said, I'm done. She decided to kill her son. But she had decided that the night before. She had everything in place. She was already in the location she was going to do it, at the boardwalk, because that's where he proposed. She was going to make David Barnes hurt. That was the purpose of killing her son. First-degree premeditated murder. The state only has to show you 3 elements and have proof beyond a reasonable doubt of 3 elements. 1, the victim is dead. That's uncontroverted, we know that. Jackson Barnes is dead. 2, the death was caused by the criminal act of Maria Rodriguez Barnes. The criminal act is putting a gun to the side of a 5-month-old baby and pulling the trigger. There's no justification and there is no excuse. And lack of memory does not negate this horrible act, even if you believe it. 3, this was a premeditated killing of the victim. Notes, texts, timing, location, all of this shows you premeditation. Premeditation is determined by you, by the facts in the case, circumstances of the case, and there's no exact period of time. Only long enough to reflect. Even if, and the state anticipates the defense might get up here and say, you know what, she didn't have a plan. Maybe she decided that if David would reconcile, she'd drive back home and let that baby live. That doesn't matter, because she said, I'm sorry for what I'm about to do. And there was time for reflection, and then she did the act. It's still premeditated, no matter how you look at it, no matter what you choose to believe. If you believe that the facts and circumstances surrounding this crime show you premeditation, then it is first-degree premeditated murder. Now, there's a second part of the verdict form. It's going to ask you to determine whether or not she discharged a firearm in committing first-degree premeditated murder. The state's going to ask you to check that box because of the ample evidence that a firearm was used. You have eyes, you know it was a Glock. There is no justification. There is no excuse. To put it succinctly, this was a first-degree premeditated murder because the state has shown you everything they need to show you for the elements of this crime. Jackson Rodriguez Barnes is dead. The death was caused by a criminal act of Maria Rodriguez Barnes. There was a premeditated killing of Jackson Rodriguez Barnes. This has been a long trial. There has been a lot of evidence, but it all boils down to, has the state given you enough to prove those three elements? And with this wealth of evidence and with all of the testimony, photographs, physical evidence, FDLE, text, notes, surveillance, her own admission, the state has proven all of these elements to you beyond a reasonable doubt. The state is asking you to go back in the jury room and find the only verdict that's in accord with the evidence, the just verdict in this case, and that's a verdict of guilty of first-degree premeditated murder for the death of 5-month-old Jackson Barnes.
Mr. McKinney?
May it please the court. Stay. Ladies and gentlemen of the jury, yesterday and today, we heard evidence about the death of Jackson Rodriguez Barnes. Something that, even from the defense perspective, was not excusable, not justifiable. I am not going to stand here and ask for either one of those things. Jackson Rodriguez Barnes is dead. There is no question about that. There is no question that the death was caused by the criminal act of Maria Rodriguez Barnes. That by itself has gotten us to manslaughter, which is a lesser included offense. Whether or not this is first-degree premeditated murder really goes to the question of premeditation. And you have seen text messages, and you can review those. You've seen notes. And you, as the jury, get to decide what you believe, what you disbelieve, and how it matters. Killing with premeditation is killing after consciously deciding to do so. And what's important in this instruction is that the decision must be present in the mind at the time of the killing. We're not talking about the day before. We're not talking about the morning of. At the moment in time, at the time of the killing. That is where a question arises, and because that question arises, that is a doubt. That doubt is reasonable, and a legal just verdict would be not guilty of first-degree premeditated murder. The defense is not asking you to find my client not guilty. The question of premeditation is a question of fact. That means you make that decision as the jury. What the lawyers say is not evidence. The story you just heard from the state is not evidence. You've seen the evidence. You can rely upon any, all, part. You make that decision from this point. We heard testimony that 2 rounds were fired, 2 rounds were located, and that the gun was jammed. We heard a 911 call that the state wanted Ms. Rodriguez to show more concern in. And in that 911 call, there's evidence that she had stopped breathing. The defense agrees that this case is not about whether or not Ms. Rodriguez tried to take her life. This case rests squarely on the issue of premeditation and whether or not the state has met their burden in a very serious case to prove beyond a reasonable doubt that the conscious decision to kill was present at the time of the killing. The reasonable doubt here exists within the state's own evidence. You have seen a lot of it. You've been very attentive over the last day and a half, 2 days. And we are relying upon you to return a legal, just verdict. Thank you.
Ms. Sandler, finally.
Defense just got up here and basically asked you to find her guilty of manslaughter. Does that sound right to you with the evidence presented in this case? The defense mentioned killing after consciously deciding to do so. I'm sorry for taking him with me. I'm sorry for what I'm about to do. Does that sound like a statement that would show there's been reflection? There's been time to think about it? That you know what you're about to do? Let's talk about the crime itself. Because they removed Jackson Rodriguez Barnes outside of the back seat of a truck. Where on the back seat of that truck, you could see where that bullet went through, that close range wound, killing after consciously deciding to do so. Killing after consciously deciding to do so. That is a conscious decision to put a 5-month-old infant in the back of a truck, put a gun up to his side, and pull the trigger to obliterate his little organs and kill him. That is graphic, but I cannot put it any simpler or better than that. That is a conscious decision to do so, and that is first-degree premeditated murder. The 911 call. What did you hear? Her name, she could talk, Maria Rodriguez. Mr. Douglas thought she stopped breathing. How do we know she didn't actually stop breathing? Because we've got J.D. Burnham coming in. She's still breathing. She's still talking. When J.D. Burnham shows up, at any time did she express concern for her son? No. Because she knew he was dead. Because she had consciously decided beforehand to kill him. There is an overwhelming amount of evidence in this case. The state has tediously gone through it with you to show that Maria Rodriguez Barnes consciously decided the day before what she was going to do. And then she called David Barnes and did it. Maria Rodriguez Barnes killed after consciously deciding to do so. And you can tell that based on the evidence, based on the facts, based on the circumstances of this case. She decided to kill her son. First-degree premeditated murder has those 3 elements. Her deciding to kill her son fits that premeditation one. The defense told you that's the only one that's controverted here today. The state has given you the evidence of that. The state asks of you to please go back in the jury room and find the just and true verdict in accord with the evidence of this case, and find Maria Rodriguez Barnes guilty of killing, after consciously deciding to do so, her 5-month-old son, Jackson Barnes. Thank you.
Counsel, if you'll please approach. So before I hand out one more instruction and then read the final instruction, the toughest thing I have to do administratively, especially on a multi-day trial, is to release the alternates, Mr. Tucci and Ms. Dewsome. You're the alternates. We appreciate your time and effort. If you'll please take your legal pads, give them to the bailiff, and you're now discharged. Thank you. Rachel, if you don't mind. So the bailiff is handing you the rules for deliberation, and then there's one more instruction that I'll give you after that, and then the jury will go back to deliberate. These are some of the general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. So the final instruction to you, which you don't have a copy of, but I'll read it to you. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During your deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until that juror returns. You are not to communicate with any person outside of the jury room about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as email or any other means. Do not contact anyone to assist you during your deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violations of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the bailiff. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer it, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. However, if you wish to see the firearm exhibit, or if you wish to see any of the biohazard exhibits, please request those in writing. And if you do request those, then we'll bring you back into the courtroom and you'll be shown those exhibits here in the courtroom. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. So if you'll please take your notes, your jury instructions. In just a moment, you'll follow the deputy out. Then I'll send in the exhibits other than the firearm and the biohazardous or biohazardous exhibits. So if you'll please follow the deputy out, please stand for the jury. Thank you. Please be seated.
Yep. Your Honor, do they have a copy of the verdict form?
Madam Clerk, does it? Yes, sir.
Okay.
Okay, before the evidence goes back, I just want to make sure, before the attorneys look at that, is, so 2 is not going back.
I have also looking back.
Okay. Yes, ma'am. If I can see it, that'd be great. Thank you, ma'am. Okay, so you have a list of what is going back, but not. No, ma'am, just the numbers were correct. Okay, so Madam Clerk has number 35, the buccal swab. We're not going to send those back? Is that accurate?
That would be accurate, Your Honor. Those are biohazards.
Correct.